31. Legal fictions, the straw man, and the commercial vessel construct. At the center of many modern legal and commercial systems lies the doctrine of a legal fiction, a construct that separates the natural person from the artificial entity known in commerce as the straw man. The speaker explains that at birth, individuals are unknowingly assigned a commercial vessel through registration, often marked by a birth certificate. This certificate operates as a title to a corporate person, which is then used by governments and financial institutions to track, tax, and regulate human activity through administrative jurisdiction. This artificial entity, often stylized in all capital letters, is treated in law as a trust, corporation, or vessel, subject to civil codes and commercial statutes. The natural living man or woman, by default, is presumed to act as the surety for this entity unless they rebut the presumption and assert their status as the secured party creditor. Understanding this construct is essential for those seeking administrative remedy. Most presentments, traffic tickets, tax demands, court summonses, are directed not at the living being, but at the legal fiction. By responding from the standpoint of the living principle and conditionally accepting on behalf of the fiction, one separates their legal identity from the commercial entity and reclaims their jurisdictional standing. The key lies in knowing when, where, and how to operate as the agent for the straw man while reserving all rights as the living creditor. The fiction is not evil, it is a tool. But when left unclaimed, it becomes a commercial liability rather than an asset. Footnote. This section explains the nature of legal fictions and the straw man as commercial entities, and how individuals may reclaim their status by separating from the artificial vessel. 32. Reclaiming title to the name, operating as principal over the entity. Once the legal fiction or straw man is understood as a separate commercial entity, the next step is to lawfully reclaim control over it. The speaker explains that this is done by asserting oneself as the principal, executor, or authorized agent over the name, the estate, rather than operating as its trustee or surety. In commercial terms, this is a shift from debtor to creditor, from subject to sovereign. The system treats the unclaimed legal name as abandoned property under public administration. Courts, banks, and government agencies act upon it as if it is public domain, unless and until someone steps forward and asserts their beneficial interest and authority over the name. This is done administratively, not by argument or litigation. A properly constructed declaration of status, affidavit of ownership, or private trust claim may be used to notify all relevant parties that one is operating as the living man or woman and has reclaimed the title to the artificial entity. This does not mean rejecting the name, but using it with clarity and authority, much like an executor manages an estate. When done correctly, the individual ceases to be presumed a ward of the state and begins to operate as the lawful title holder to the commercial entity. Control of the name is not automatic, it must be asserted, demonstrated, and perfected through lawful conduct. This is the commercial path to autonomy. Footnote. This section outlines the process of reclaiming control over the legal name by asserting principal status and operating with authority over the commercial estate. 33. The three-tier structure, trustee, beneficiary, and executor. Understanding the trust relationship between the individual, the state, and the commercial entity is essential for asserting lawful standing. The speaker outlines a three-tier structure, trustee, beneficiary, and executor, which governs nearly all modern legal and financial interactions. Each role carries distinct rights and responsibilities, and failure to claim the correct role leads to presumption of liability. In most legal encounters, the system presumes that the living individual is acting as the trustee for the public trust, the straw man or legal fiction. The trustee bears the obligations, liabilities, and enforcement risk. Conversely, the beneficiary enjoys the privileges and benefits of the trust without liability. However, true commercial control lies with the executor, who holds the power to direct the trustee and protect the interests of the beneficiary. By understanding and asserting one's role as executor or authorized representative, the individual avoids inadvertently accepting liability as trustee. This is done through affidavits, notices of status, and conditional acceptances that clarify one's position and deny unauthorized assumptions of liability. The state and its agents often act as administrators over the unclaimed estate, the legal name. But when the executor appears and claims the estate, the administrative authority must defer, provided the claim is made in honor, with proper documentation, and supported by commercial process. Jurisdiction follows capacity, and capacity follows declared standing. Footnote. This section explains how the roles of trustee, beneficiary, and executor define one's standing and liability, and how asserting the executor role restores control over the commercial estate. 34. The UCC-1 financing statement, securing the interest in the legal entity. The UCC-1 financing statement is the principal instrument used to publicly declare a secured interest in personal property, including the legal name or strawman entity. The speaker explains that by filing a UCC-1, the living man or woman acts as a secured party creditor, establishing a public record that they hold a first position lien or claim over the artificial commercial entity often created without their knowledge at birth. This filing does not alter the legal name or attempt to reject it. Instead, it perfects the claim by notifying the world, through the Secretary of State's office, that the filer has a superior commercial interest in the property described, which includes the debtor entity identified in all capital letters. In legal effect, the UCC-1 establishes that the state, courts, and other entities may no longer presume ownership or priority claim over the registered name or its associated assets. Accompanying the UCC-1 are often additional documents, a security agreement, establishing the terms under which the debtor, the strawman, uses the assets, and an affidavit of truth or declaration of status, which substantiates the relationship. These records are supported by proper procedure, mailing, notarization, and retention of originals, to form a complete commercial claim of right. By using the same legal tools that banks and corporations use, individuals step into their rightful role as secured parties, shifting from presumed debtors to recognized creditors with lawful title. Footnote. This section details how filing a UCC-1 financing statement perfects a secured interest in the legal name, establishing creditor standing and limiting external claims. 35. Conditional acceptance as a tool of honor and commercial control. Conditional acceptance is one of the most powerful instruments in commercial law. Rather than outright refusing a demand or arguing with a presentment, the individual may reply, "I conditionally accept upon proof of claim." This statement, though simple in form, is deeply rooted in law merchant doctrine and operates to preserve honor while shifting the burden of proof to the presenter. The speaker emphasizes that dishonor occurs not only through refusal but also through silence or non-response. Conditional acceptance ensures that one stays in honor while preserving their administrative rights. It requires the other party to validate their authority, standing, or claim, often something they are unable or unwilling to do. In the absence of proof, default follows. The power of this tool lies in its dual function. It avoids controversy, which would signal dishonor, and creates a record of performance, which can later be used to establish default. A conditional acceptance may be followed by an affidavit of facts, a notice of fault, and finally, a notice of default and opportunity to cure. This creates a private administrative judgment based solely on unrebutted documentation. Properly used, conditional acceptance neutralizes enforcement actions, compels lawful validation of claims, and positions the respondent as the creditor in commerce. It is not refusal, it is conditional agreement based on lawful requirements, the most powerful expression of consent under terms. Footnote. This section explains how conditional acceptance maintains honor, compels validation, and initiates lawful remedy through administrative default. 36. Administrative default as final judgment and enforcement mechanism. An administrative default arises when a lawful presentment or offer, properly documented and delivered, is met with silence, refusal, or an insufficient response. Under the rules of commerce, silence following a conditional acceptance is treated as tacit agreement and final consent. The speaker explains that this default process, when carried through the proper administrative steps, results in a binding private judgment, enforceable under commercial law. The procedure typically involves 4 stages. 1. Initial presentment or conditional acceptance. 2. Affidavit of facts, documenting the sequence of events. 3. Notice of fault, giving the opposing party opportunity to cure. 4. Notice of default, solidifying the agreement through silence or failure to rebut. Each of these steps must be completed with evidence of service, such as certified mail or a notary's journal entry, and must offer reasonable time to respond, usually 10 to 15 days. Once the notice of default is issued and goes unanswered, the facts become adjudicated by default, not through court, but by operation of law. This final administrative judgment may then be used as the basis for filing a lien, asserting a claim, or offsetting an alleged debt. Because it is based on commercial process and lawful notice, courts and agencies must either rebut the record or accept it. When properly constructed, the default process is not theoretical, it is enforceable, final, and lawfully binding. Footnote. This section details the steps and legal effect of administrative default, which results in a binding judgment when unrebutted. 37. Standing as creditor, the importance of status in commerce. In the world of commerce, standing is everything. The speaker underscores that only a creditor, one who provides substance, offers remedy, or holds lawful claim, can compel performance or enforce remedy. In contrast, a debtor merely exists under obligation, subject to the demands of others. The shift from debtor to creditor does not happen automatically, it is a function of declared status, lawful conduct, and perfected record-keeping. One demonstrates standing as creditor by executing proper notice, offering performance through conditional acceptance, and documenting the other party's default. This is not about wealth, power, or position, it is about procedural control. The creditor offers remedy, while the debtor seeks excuse. The creditor initiates the commercial record, while the debtor remains silent or reacts under presumption. Standing is also tied to jurisdiction. By claiming the role of executor, secured party, or authorized agent, the individual steps out of the public domain and into the private jurisdiction, where commercial rules, not statutes, govern conduct. This distinction separates one from presumptive liability and places them above the fold in any commercial proceeding. Crucially, this standing must be proven through action, not asserted through theory. A creditor is one who behaves as such, calm, competent, procedural, and always in honor. This role gives rise to lawful remedy, while all other roles merely react to obligations imposed by others. Footnote. This section defines creditor status as a procedural and evidentiary position of power in commerce, determined by lawful action and standing. 38. The private administrative process versus the public court system. The speaker draws a sharp distinction between the private administrative process and the public court system, emphasizing that while both aim to resolve disputes, their structures, jurisdictions, and philosophies differ dramatically. The public system operates under statutory law, presumption, and adversarial procedure, while the private side, governed by commerce and contract, relies on notice, opportunity to cure, and administrative default. In public courts, the individual is often presumed to be a ward of the state or an agent of the legal fiction. This presumption places the burden of proof on the defendant, and judgments are rendered by third parties. In contrast, the private process recognizes the individual as a principal party to a contract, capable of creating enforceable records without external adjudication. The private process is initiated by the individual, proceeds by conditional acceptance, and is finalized by unrebutted affidavit or silence. When properly executed, the resulting record is as binding as a court judgment. In fact, if brought into court, the unrebutted administrative record must be addressed before any statutory arguments can be considered. However, the speaker warns that to operate privately, one must do so with precision and honor. Sloppy paperwork, unserved notices, or combative responses destroy standing and trigger jurisdictional loss. The public court system functions by default for those who fail to operate competently in the private realm. Remedy is not denied, it is simply unused by most. Footnote. This section contrasts the private administrative remedy with public court procedure, highlighting jurisdictional authority and the importance of lawful record keeping. 39. Presentment and dishonor, the sequence that triggers remedy. At the core of commercial enforcement lies the ancient and still operative process of presentment and dishonor. The speaker explains that every remedy begins with a lawful offer or demand being made. This is the presentment. It is not the argument, but the offer that gives rise to the obligation. When the offer is ignored, refused without cause, or rebutted ineffectively, a dishonor occurs. Under UCC Article 3 and the law merchant, dishonor is the legal trigger for default and enforcement. A valid presentment must be delivered in writing, served with proof, such as certified mail, and offer a window of time for the other party to respond. If the recipient fails to respond within the time frame, typically 10 to 15 days, then dishonor is established by operation of law. The party who presented now has standing to issue a notice of fault, followed by a notice of default and opportunity to cure. Dishonor is not personal, it is procedural. Once it occurs, it gives rise to rights in favor of the presenter, the right to perfect a commercial lien, file a bond claim, assert creditor status, or use the record as defense in a statutory proceeding. Courts may resist this process, but they cannot override it when the record is complete and unrebutted. Thus, the dance between offer and dishonor is not about debate. It is about timing, precision, and lawful documentation. Without presentment, there is no claim. Without dishonor, there is no default. But with both, remedy becomes enforceable. Footnote. This section explains how lawful presentment followed by dishonor initiates the commercial process of default, enabling enforcement of remedy. 40. Commerce is the foundation of modern law and governance. The speaker asserts that virtually all modern law, whether civil, criminal, or administrative, has been absorbed into the commercial framework. From banking and taxation to judicial process and regulatory enforcement, the governing principle is no longer the Constitution or common law in its original form, but rather contracts, performance, and commercial obligation. This is the unseen structure behind the visible institutions of government and law. This transformation stems largely from the global abandonment of the gold standard, the rise of negotiable instruments, and the monetization of human activity through bonding, securitization, and registration. Today, every legal process is initiated by an offer, whether implicit or express, and all enforcement derives from consent, either express or presumed through silence or action. In this context, understanding commerce is no longer optional, it is the key to lawful remedy. All government agencies, from the IRS to the DMV to the courts, operate in commercial capacity as corporate entities. They rely on your contractual participation, your failure to rebut, and your silent acquiescence to enforce rules, extract fines, and secure judgments. Operating in the private requires recognizing this reality and responding in kind, not through protest, but through lawful commercial process. Remedy does not lie in fighting the system, but in understanding it, and then acting from the position of a competent creditor who knows how to contract, how to rebut, and how to enforce through procedure. Footnote. This section explains how modern governance is built upon commercial principles, making commercial law the dominant framework for lawful remedy. 41. The Creditor's Mindset, Peace, Precision, and Procedural Mastery. The final and perhaps most essential element of effective remedy is the development of the creditor's mindset. The speaker emphasizes that remedy is not merely about paperwork or technical filings, it is about a way of thinking and being. A true creditor does not argue, panic, or fight. Instead, they remain peaceful, focused, and procedurally exact, even when provoked. This mindset is rooted in honor, not resistance. The creditor offers remedy, never engages in controversy, and never volunteers to step into the role of a debtor. Every word, every response, and every action is deliberate and lawful. If challenged, the creditor does not react emotionally but relies on the record already established through notices, affidavits, and defaults. The creditor is also proactive. They do not wait for conflict, but set terms, make offers, and define the jurisdiction in which they operate. They understand that commercial remedy is not achieved through litigation, but through documentation and silence, backed by the law merchant and the Uniform Commercial Code. Ultimately, the creditor's power lies in their self-governance. By maintaining internal order, they gain external control. This is not esoteric theory, it is a lawful and historical truth, practiced by those who operate in the private, enforce remedy without confrontation, and leave no room for assumption or controversy. Footnote: this section emphasizes that the true power of a creditor lies in peaceful conduct, precise process, and unwavering control of one's jurisdiction.